Hello everyone, this is the video of Legal Studies class 12 unit 2 and the topic is discharge of contract by breach of contract. So what is meaning of breach of contract? So first you need to understand the meaning of breach. Simple English term breach. What does it mean? So the literal meaning of breach is violation, infringement, infraction, transgression, neglect, etc. So this is the English meaning of breach. Now let's check it out. What does it mean in law? So breach means breaking or failing to observe a law, agreement or code of conduct. So what does it mean? That whatever the liabilities you have been given through the contract, so you didn't complete that through the performance, or in other words you deliberately failed to perform. So that is breach. Okay. Now in reference to our topic, a breach of contract occurs when one of the parties of the contract thereto renounces or fails to perform, as we discussed just now, his obligation or even refuses to perform. So by the time we have studied the discharge of contract by natural means the act that is beyond the control of the person. But in this case, it is very much in the control of the person, but he refused or deliberately didn't perform his or her part. So that is breach of contract. So now let's check it out what section 39 of Indian Contract Act states. When a party to a contract has refused to perform, see the language. When a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct his acquiescence in its continuance. I believe again this definition is complicated for you to appreciate, but don't worry, I will simplify it for you. So let's check out clause by clause. As it is saying, when a party to a contract has refused to perform, very much clear, means you have contracted with someone that certain things will be done, but later on at the middle of the contract you might refuse not to perform your part. So that is clear. Or disabled himself by any means, you restrained yourself by any means, but it has to be deliberate, not something like beyond your control. His promise in its entirety means now you are not going to perform your part. Entirety, not in the part, rather entirety. So you are abandoning that contract there itself on your part. The promisee may put an end to the contract. So in this case, what promisee can do, because of your refusal or your failure, promisee can put this contract at the end here itself, or unless he has signified by words or conduct. What does it mean? That because of your refusal, your failure, if promisee wants to continue with the same contract, then fine, the contract will be valid, and that his consent either given by words or through conduct, that is acquiescence, consent. in its continuance, means to continue the contract. Now, still I believe you have some confusion, but check out with an example, it will help you. A was a singer and he contracted with B, who was a theatre manager, and that A promised that every week 2 days, in a week 2 days, A will sing in B's theatre, okay, and against that performance B will give 100 rupees for each performance. So what happened? And this contract made for 2 months. So after 2 weeks, what happened? A, without informing B, deliberately escaped and didn't appear to sing the song. Okay, so as per the provision that section 39 defines, now B has right to end this contract here itself. Okay, though it is made for 2 months, but since A is breached, okay, so in that case B has the right to end the or terminate the contract here itself. Okay, on the other hand, because we have this next clause in the definition, that is, unless he has signified by words or conduct. So see this clause, how it is defined through the example. So second example, A is a singer who just made contract with B, who is a theatre manager, and in a week he will sing 2 days, and B will give him 100 rupees for each performance. Okay, so and it is made for the 6 months. So what happened after 2 weeks? A willfully didn't appear for the performance. Because of that, we are obviously going to be in loss. But what we did, next day when A appeared to perform, B didn't say anything, rather he allowed to perform. So because of this conduct, the contract now is continued, so it won't be terminated. And since B has allowed A to perform, then now B cannot terminate based on that breach of contract that A already did last day. Okay, but still B has the right to demand lawfully the damages that B suffered because of A's breach of contract. So this definition has two parts, that if someone is breached, then the promisee has the right to terminate the contract there itself, or depending upon his nature or mood, he can still continue with the same contract, but still he has the right to demand the damages that he suffered because of other party's breach of contract. So this is all about the breach of contract. Okay, and this is also known as waiving the breach, because as you have seen in this example that B allowed A to perform. Okay, so B waived A his breach. So this is also known as waiving the breach. Now the interesting part, that is remedies for breach of contract. Of course, if someone breached contract, then what is remedy, because other party is going to suffer. So in that case, the person injured by a breach of contract has been given right to claim the damages from the party for compensating the loss suffered. Okay, now let's check out what section 73 of Indian Contract Act states. It says simply that when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract, okay, compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things. Now you have to pay attention here only, because the rest of the things it's easy, but this point, that is naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. So now let us check out what this definition is actually saying. This definition is simply saying that the person who breached, so in that case the promisee, the other party, has the right to claim the damage. This part clear? Okay. But how much? The question is how much he can claim. So this section defining how much he can claim. It is saying that 2 points. The first one, as saying here, arose in the usual course of things. So whatever the damages that usually you suffered, okay, and the second, whatever the damage is already known both of you, that if any party is supposed to be breaching at any point in time, then this much loss will happen and this much the defaulter party will pay. So that is already fixed, fine. If not fixed, then in the usual course of things, so whatever the loss you suffered normally, that will be given to you. So the party in loss or who suffers is entitled to receive compensation. The party who has broken the contract liable to pay the compensation. Okay, very much clear this point. As I have explained while defining the concept or provision, that is how much it is paid. Now note, such compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach. So another point that you need to focus here, that is remote and indirect loss. So it's not something like a speculating or making assumption that if you would have completed your part, then I would have been got something more or some project. I didn't get that, so you have to pay also for that project. It's not like that. And yes, the example that is given here, that will simplify your dot. Okay. In this example, there were two persons, A and B. A is the mill owner, okay, and his machine stopped working. So there may be some minor error or whatever the things. So A called B to deliver a new machine as his work is stopped. B promised that I will be delivering you by tomorrow morning. But what happened? B delayed the delivery. And in the course of time, what happened? A was about to getting a project from government. Okay, so that project he missed as B delayed the delivery. Okay, B delayed the delivery 2 days, and he, A, basically he didn't only suffer the loss of that 2 days, but also suffered the project that he was about to get from the government. So in this case, what was the amount that A is going to claim? That is only the 2 days delayed amount that he basically suffered or in loss, okay, as his mill was not working for next 2 days, but not against that project that he lost. Okay, so that is something like remote, indirect loss. So the party who breached, he doesn't suppose to pay the damages, that is an assumption, that is remote. Okay, so whatever the things fall in the usual course, the breached party is liable to pay only that. So direct loss, not the remote loss or not the indirect loss, only the direct loss. Okay, so that is the purpose to calculating the damages. Now come to the next part, that is what is meaning of damages, because already we have discussed that the party who suffered can claim the damages. But what is meaning of damages? The compensation in terms of money for the loss suffered by the injured party is known as damages. Okay, so it is normally the money. Okay, however, burden lies on the injured party to prove his loss. So of course, if you are claiming that you suffered certain amount or certain things, then it is your liability, it is your duty to prove in the court that you suffered, not the opposite party. Okay, keep in mind. So now there are two principles of damages on which it is calculated. Issue of damages is normally resolved through two principles, that is remoteness of damage, we have already discussed that through that example, and measure of damages. So once you decided, once you fixed that things, what you suffered, how much you suffered, only then you can measure the damages basically in terms of money. Okay, so first principle, what it says, that is remoteness of damages. Okay, so let's understand it with an example. I just read it out and again I will explain that. A ship owner contracts with B to convey him from Calcutta to Sydney in A's ship. Okay, sailing on the 1st of January, and B pays to A by way of deposit 1/2 of his passage money. So what it is saying basically, that A, who is a ship owner, that is sailing the ship from Kolkata to Sydney, that is in Australia. Okay, so he promised B that I will carry you from Kolkata to Sydney, and for that B has given the 1/2 of the fare, and the journey will start on the 1st of January. But what happened? The ship doesn't sail on the 1st of January, and B, after being in consequence detained in Kolkata for some time and thereby put to some expense. So since ship didn't start on the aforesaid date, so B had to stay in the Kolkata only. Okay, so his expenses increased of staying in the Kolkata. Starting from here only, you can keep calculating. Okay, okay, then what happened? What then B did? B just hired another ship to go to the Sydney. So what he did? He just bought the ticket of another ship and then went Sydney. So he suffered how much losses? The first one, that he stayed additional days in the Kolkata. So for those days you can calculate, say he stayed for 5 days. Per day his expenses was around 1000 rupees. So 5000 rupees, first thing that you need to calculate. Secondly, say A's ship was carrying him at the price of 2000 rupees. But now the new ship by which he reached Sydney, he charged him 3000 rupees. So 1000 extra he paid to that ship. So 1000 plus that 5000, that is he detained in Kolkata, so 6000. And now he reached Australia, that is Sydney. So whatever the some expenses that he lost there, so that is. But it doesn't mean that any remote something like that, because he reached there something like 5 days late, so he missed his job or some project. So for that A is not liable to pay. Only in the regular course, whatever the loss be suffered, A is liable to pay only that. So 5,000 in Kolkata, 1,000 the additional charge on ship, and a few thousand maybe in Australia because of some other reason. That's it. But not the other thing that he missed the project, he missed the job or something like that. Not for that. That is remote damages. And remoteness of damages is defining these things. So that is indirect loss. So A is not liable to pay the. We have seen that what is the definition of remoteness of damages, what are the examples. So now check out the meaning. Through this principle, we identify the losses which are the direct result of the breach of contract. We are discussing only the direct loss, not the indirect. The former Chief Justice of India, namely Justice Patanjali Sastry, said that the party in breach must make compensation in respect of the direct consequences flowing from the breach and not in respect of loss or damage indirectly or remotely caused. So very much clear. Even this gentleman, that is former Chief Justice of India, also saying that only the direct damages that is liable to be paid and not the indirect. So now the second principle that we have, remember, that is measure of damages. So now it is fixed that these are the direct damages. So now measuring how much. After applying the remoteness of damage, once the damage is determined, then it is evaluated in terms of money. As we have seen in case of that ship that is supposed to be carrying B from Kolkata to Sydney. So we have seen there how we have calculated. Okay, so that is measure of damages. Note, apart from the provisions of Indian Contract Act, the party who is in loss can also seek compensation under a Special Relief Act. So this provision is saying that we have another law, that is a Special Relief Act. Under that you can also claim the damages. So now you have two provisions, under the Contract Act and under the Special Relief Act. So under these two provisions you have right to claim your loss. Okay, so this is all for this video that we have discussed, that is the discharge of contract by breach of contract. Okay, and we have seen the meaning, the provision and all, and we have also seen the damages, what is meaning of damages and how it is measured. So these are the things that we have discussed, and I believe you must understood all these meanings. If didn't understand, then I request you to watch this video again and again, and you can have the animation and the visual presentation that will help you to understand it. And this is the purpose, that defining these concepts through these animations and visual presentations. So watch it again and again. See you in next video.